Suffering an injury in an accident can leave you overwhelmed with medical bills and lost wages, and the thought of hiring legal counsel might seem out of reach. When you're trying to get back on your feet, it's easy to delay calling someone because you assume you can't afford representation. Understanding how fees are handled in personal injury matters can give you confidence to move forward and get the help you need. In most practice areas, people must pay for representation out of pocket, but personal injury cases operate differently. At the firm, the fee arrangement is based on a contingency, meaning clients pay nothing up front and the firm only receives compensation if money is recovered. Arkansas Rule 1.5(c) of the Rules of Professional Conduct requires that any contingent fee agreement be in writing. The written contract must clearly state the percentage of the recovery that will go to the attorney in the event of a settlement, trial or appeal, explain whether costs and expenses will be deducted before or after the fee is calculated, and specify which expenses the client is responsible for regardless of the outcome. The rule also requires the lawyer to provide a written statement at the conclusion of the matter outlining the result, the total recovery amount and how fees and expenses were calculated, so there are no surprises. The direct answer to the question of payment is that you don't need to worry about paying an advocate out of pocket. The firm works on a contingency basis, meaning their compensation comes as a percentage of your settlement or award. If no recovery is made, you owe nothing for legal fees. Because this structure defers payment until the end, it allows injured people to pursue their rights without adding financial stress during recovery. The firm also covers case-related costs, such as expert witnesses, filing suits, depositions, and obtaining medical records or accident reports. These expenses are reimbursed from the compensation secured, but if the case does not result in a recovery, the responsibility stays with the firm. Clients face no upfront financial risk, and their credit or financial standing is not affected. Working with an attorney on a contingency basis will not harm your credit because no fees are owed unless a recovery is made. A contingency fee arrangement may differ slightly depending on whether a matter settles out of court or proceeds to trial, but clients always agree to the percentage ahead of time so they know exactly what to expect. Because everything must be in writing, including a post-case accounting, clients receive transparency at every stage. The agreement outlines how costs will be handled and requires counsel to provide a written statement after the matter concludes detailing the outcome and the amount the client will receive after deductions. Joseph Gates founded his own practice after earning his J.D. from the University of Arkansas School of Law in 2010 and working at Taylor King & Amp Associates and later joining another firm. With more than a decade of experience representing individuals harmed by negligence, he is known for compassionate, results-driven advocacy. He serves on the boards of governors for the Arkansas Trial Lawyers Association and the American Association for Justice. His commitment to clients and personalized representation has made his practice a trusted resource for those who have suffered serious injuries. Through their fee structure, Gates' law firm ensures that anyone injured by someone else's negligence can seek compensation without worrying about the cost of hiring help. By taking on the financial risk themselves, they allow clients to focus on healing. If you need guidance after an accident and want to learn more about how contingency agreements work, contact Gates Law Firm, PLLC at 2725 Cantrell Road No. 105, Little Rock, Arkansas, 72202. You can reach them at 501-779-8091.